gracious presence only can provide us a light about the intellectual property. And sir, on behalf of Patent Promotion and IP Cell, Notia University, I welcome you in today's session. And really, I appreciate that you have devoted your valuable time and you have given your consent to remain present and to give a deliberation in this very session. We extend very grateful thanks from core of our heart. We welcome you to this very program, sir. Thank you very much.
Uh, Thank you very much, sir. It is indeed a great pleasure for me to address the August gathering and the Honorable Vice Chancellor, most respected Vice Chancellor, Dean, and other faculty members of the most respected University of Calcutta, and also to my friend Sabji. So, for all of you, it's indeed first I should convey my gratitude for having given me this excellent opportunity to share my views with regard to the geographical indications. The geographical indications is basically a law which will definitely promote the rural poor. How and what way, and what are all the basic requirements for developing the rural economy so that the national building exercise can be carried on and on to ensure that what is the need of this hour. That is what is going to be the highlight of our session, and how to register a GA, what is the requirement, to what level, to my understanding, what we have reached, and what are all the things that we have left out uh, uh, to get the recognition in the GA. Because it's a thing when we start doing it, I want to run a video for a 2 or 3 minutes, which is potentially will highlight the significance and how to go for the recognition of GA, that too from starting from Kashmir. I will come down to Kanyakumari in the later part of my lecture. So, with all your privilege, may I have the honor of presenting a video for 2 to 3 minutes, which is from this news channel, Beyond, which I want to highlight you how to go about for a GA recognition.
Natarajan sir, sir, may I humbly point out that we cannot listen to the audio.
So, give us. Okay, we will go to other slides.
GI tagging will also help in raising the price of the A study was released recently by the Finance Minister of India.
Is it audible?
Called Indian Sports Goods
Is it audible?
Strategies for
Yes, sir. Yes, sir.
Okay.
It showed that there are no registered GIs in the sports goods industry in India. The study revealed that the Kashmir willow bat is one such product which holds significance as it is made from some of the best quality wood in the world. The bat makers in Kashmir are eagerly waiting for the GI tag. It's a good step by the government and we have been expecting it. The government is helping the small scale industries at the moment, and due to this Kashmir willow, we will get the recognition it deserves. The English willow is considered good, but the Kashmir willow is as good. And if we get the tagging, it would help us. The top grade willow bats are good and need to be promoted as much. If we have GI tags, the sales will go up. There are more than 200 bat making factories in Kashmir, and hundreds of people are earning their
To understand what is basically the GI is. It's a territorial nexus connected to the product emanated from that particular area or region. So with this introduction of that slide that we have started from Kashmir, let us end our discussion with Kanyakumari in due course. And let me talk about the pre-trip scenario. What made the government of India to go for a unionist legislation of GA? So earlier the situation before the TRIPS, trade-related intellectual property rights, the scenario was there was a widespread imitation, usurpation of all GA. GA is nothing but a tradition and heritage you are able to establish. And what is the requirement of law? Then we go for it. It is either the production or processing or the production or processing or both. As even the raw material as there is no need for the raw material to grow from that particular area, you should come from that particular region only. These are all the aspects we will be discussing in the course of our discussion. First, the thing is, if you the law, three important parameters for the recognition of GI being one being the quality, yes, one being the quality or the reputation or the essential elements which are attributable to its territorial limits or territorial origin, as the case may be. Territorial limits, that is it is attributable to its territorial region, especially relates to the agricultural, horticulture. With regard to the other two things, what do you call it as the quality and reputation? Even the local reputation is sufficient to stake a claim. In that situation, how far we have achieved the good for in the Indian scenario, which we have to evaluate, we have to form a way out to ensure that the national building exercise is going on and on to ensure that the rural poor are taken care of in the right perspective, and that too in the Corona scenario where everyone is running back to their native place. The best medicine, it is I'm telling you in front of this forum, that is only the GAs can protect the rural poor. GA can only save the what do you call it as a movement of persons from a particular place to another place. So this local settlement, that being the objective of the legislation, that being the purpose of the legislation, that being the motto behind the formulation of this legislation, how far we have achieved good is a question to be debated now. So in the pre-tips is nothing but a Ramayana slide where and what is the medicine that has been given. Medicine that was given that we will test when I reach that destination. So in the pre-trip scenario, the global situation was, so everyone has to fight for their reputation. Even market tactics was used by the disruption in the market. So then in India, what was the situation? In India, it was the main purpose behind the enactment of GA law being the TRIPS obligation, because India was forced to protect its treasures, which is available in an abandoned way. And whether we have trapped it or not, that is the issue which we are going to debate before this August gathering. So need to protect the Indian treasures like Darjeeling tea, basmati rice, Bikini Ujia, Alfonso mango, and the special given gift that we have achieved a greatness and the entire globe. There is no match to India. I can tell you before this forum that Indians' recognition of the method of recognition of GA is globally, what do you call it as, no less to any country in the globe, because the specification, the description, the method of production, the manner of sufficient advertisement, the what do you call it as the latitude and longitude covering the widespread area as the case may be, all have been taken proper care. How, what level the care has been taken, which I'm going to tell you what I have experienced as one of the members of the consultative group, where eminent scholars, eminent jurists, eminent personalities, no match to them, and everything you can see when you go when you go in the website, and you can find in a fantastic way. It is itself is a pleasure. Kindly excuse me. It's a pleasure. It's a pleasure to see and read and read. So that being the case, we can go to the next part of it. As far as India is concerned, the concept of uniqueness of product. We are telling globally that champagne, but I feel the olden days, Sura and Soma, Banam, which was supposed to be prevalent and was given to the guest, no match to it, because for want of documentation and other material information to prove that those things are all the product emanated from our territory, we are not able to establish and get the recognition as of today. So the concept of uniqueness of products of certain geographical region has been recognized from ancient time. in Hindu scriptures, the Ramayana, the mythological Sanjeevani booty, sea-buck thrown fruit, suppose a magical berry grown in the Ladakh region of northern India. There it emanates from our India. The Karma Bhumi of India, where it emanates from the northern India region, used to bring back Lakshman to life when he fell in the battle with Indrajit. So this being the important thing that we have to take into consideration. And as far as your eastern side and northeast a gold mine, and all medicinal plants are available. How many medicinal plants have gone into the register of the GA? Can anyone tell me? Where we stand. That is what the issue we are going to discuss. Why these things have not been taken? These things have not been taken in the proper perspective. That being the folly, which hopefully it is my personal view, there we committed the mistake. What we have committed mistake is that wherever you go, internationally you see, without university, there is no movement. We are on track now. You see America. Why America is so popular? Because of the various universities, because of the students, young generation, their thinking, their method, their approach, which is vibrant, which is missing as far as the elderly people like me is concerned. So when we have an approach of concept emanates from that of an university, it will have all effect, the resource, the material force required for recognition. So now we started doing it. It is a pleasure to address an university, not to address an industrial unit, because I can rest assured that not less than 20 applications can be filed within a year's time. Hopefully, if everything goes on well, even from most respected university of your caliber. So then the next immediate question is there a necessity for us to go for a GI registration? Is it what is the requirement to call for a GI sui generis legislation in India? That is what the imperative, the reason being to prevent GI becoming generic. What is generic? That is protected. That I will let you know in the next slide. Need-based system that is open, fair, and provide for an enforcement mechanism in India. Basically, one of the mandates of TRIPS, that being, unless geographical indication is protected in the country of its origin, there is no obligation under the TRIPS agreement for other countries to accept reciprocal protection. So if you are not recognized your GA, there is no obligation for us to recognize the GAs of yours. So India would, on the hand, the next thing is be required to extend protection to goods imported from other countries which provide such protection. That being the basic cause for going for a sui generis legislation. As per Section 9F, what we call it as the generic terms of the Geographical Indication Registration Protection Act 1999. In the context of geographical indication, generic terms are names which, although denote the place from where a product originates, have become the term customary of such a product. For example, Xerox. So Xerox is example of GA that has become a generic term. I have given you a Mysore Pak. Mysore is a place. So Mysore Pak is a sweet dish normally available in the South Indian region. So we can say it has lost its identity, distinctiveness, and that has become generic. The question is like this: can you tell everything has become a generic? Example is, some of them are showing even a Kumbakonam coffee, a filter coffee emanates from a tiny small village, a rural packet, in the South India called as decree coffee. Kumbakonam decree coffee. If you take decree coffee, it will give a kick in your brain. So it is so thick and it has got some type of specification which will really kindle your brain power. So everyone in South India used to take the Kumbakonam coffee only. Everybody in India, irrespective of this, this is what an aspect which I want to highlight before the university. Because of the non-recognition of very important products of this nature, everyone started using the term Kumbakonam coffee in South India. But does it mean that it covers the entire territory of India? Or how many of you in this discussion sitting before you is aware of this Kumbakonam coffee? India is a vast country covering a vast network simply because in a particular area it is popular and it is known throughout that region. The question is, we have to tell even the code. I am highlighting you. What is generic expression should be the last resort. It is not a protective cover. It is a preventive measure provided it lasts its identity and distinctiveness, which is not the case in the case of Kumbakonam coffee. Even people are not telling it has become semi-generic. That is the sorry state of affair prevailing in the current situation in India. And people will start telling from tomorrow onward because the fundamentally I differ with some issues. First, I am here to protect my country's product only. When my country, my people, protection to national interest is the topmost priority for anybody, any country person. And when my country is having a speciality of a particular product, simply because some of the people, for their benefit, making use of it in their thing, will it amount to that? I am asking you a very, very important issue in this connection. Many articles have to come telling that these are all the areas where we can classify as generic. Even your articles will be paving a way for the courts to decide in a critical issue. This is where the universities have got to play a very important, significant role, to my understanding. I may be wrong, or if you feel otherwise, let us discuss the other issues also. That geographical indication means what? Geographical indication refers to any indication. It's nothing but a tool. Tool for what? Tool for promotion. Promotion will lead to what? Promotion will lead to the premium of the product. That is what the difference between an ordinary product and a GI recognized product. And it will automatically, when you get a promotion to your product, premium to your product, it's sending what? It's sending the result of exporting that particular product to the other areas. I can tell you, we will in the course of discussion, it's hopefully everyone is listening to me and everyone is able to tell for the things. So when we go for this, what are all the important criteria to have this recognition as a tool? Goods as originating from a particular place, where three important criteria have been given under the law, where a given quality or reputation, I'm sorry, here or is missing, but as per the definition part, it is or, where a given, each is an independent parameter to decide the recognition for a particular product, where a given quality or reputation or other characteristics of goods is essentially attributable to its geographical origin. It's where we are going to see some of the beautiful slides where I'm going to where I have got a personal experience which I want to share with you all, where the goods may belong to an agriculture. Then the three important criteria when you go for the recognition, that is the quality or reputation, or what you call it as the other things, good characteristics which are essentially attributable, the size, shape, the nature, the fragrance, the other important elements which are all exclusivity of the agricultural and horticultural products. So when the goods may belong to agricultural, natural, manufactured, or handicrafts, including food items. I have seen over a period of 15 to this law came into force in 2003, September 15. Today, we have covered almost 17 years. We have not even crossed 700 applications. The present day trend, where I can tell you that we have got what is where we stand, where we what is the lacuna and how to go about it. That is what is going to be our discussion in the course of our this lecture. So region, locality in that territory, and in case where such goods are manufactured goods, it is very clear. Law is very simple and very clear. Highly enlightening us that you go for the recognition. And where we have gone, I have shown you the manufacturing activity, the method of production, the process, everything in the Kashmir Valley, Kashmir Valley. It is good that they are coming for the recognition at this stage. Hopefully, I asked the GA registry unofficially, the application yet to reach the GA office. But every steps have been taken for the recognition of GA has up to these bat owners, where it will definitely promote that particular product emanates from that particular territory. That is the purpose of our vision. So preparation of the goods concerned takes place in such territory, region, or locality as the case may be. Then, Indian Act provides for registration and protection of geographical indication related to goods only. There is no services involved. Services, if we have an opportunity of involving, then there is no match, I can tell you, throughout the globe. But unfortunately, it is also a debatable issue. Now, I can tell you, this is a very famous, what do you call it as Kerala massage. Very famous massage using the medicinal oil for massaging purposes. Even in London, a lot of money is made out of this, where we stand. At least those oils have to be recognized under the GA, to my understanding. All these are all the issues for I can only kindle the spirit. It's a thought-provoking process where we have to work together. We have to work unitedly to ensure more and more products are recognized, rural products are recognized, and ensure that the rural economy is developed. People are settled in the rural package so that the urbanization aspect has come down to the minimum level where everyone enjoys the life in a peaceful way. So the agricultural goods, natural goods, manufactured goods. Under manufactured goods, we have got the subcategories. It is not the subcategory. It is a category itself is defined. Handicrafts include handlooms, textile goods of foodstuffs and wines and spirits. Foodstuff. It is great that we have got the GA tag for Calcutta Rasagulla. But how many products are available, sweet dishes are available in the every village? It is available in the north now, your eastern side, I'm aware of. But how many of them have come on record? Please kindly think it over. Kindly have a thinking when you go back and do it. So that is the purpose of it. That is the basic issue which we will be debating in the course of our discussion. Goods refers to any agricultural, natural manufactured goods. Some of the Indian GIs under these categories are registered basmati. I would rather refer in this connection the first basmati application for which the law has been enacted by Government of India, mainly to recognize the basmati rice. The first application filed was application number 14. You can find in that application number 14 was refused. Why? When even the GA application filed by those people, those producers, when it is not according to the provisions of law, the office has taken, the Government of India has taken such a step to refuse even that application. What more transparency is required? It is, you can see on the record, it will speak. The issue here is why it was refused. The basic purpose of GA law is nothing but to protect the interest of the producers of the concerned good. When that objective is not achieved, what is the purpose of recognition? That being the sole reason, that being the cause for the dismissal of that application. That dismissal part, the refusal part of 28 pages have been written by 7 eminent scholars sitting for 27 days continuously, including a High Court judge, 2 vice chancellors, an eminent person from what do you call it as the rice, that is what you call it as the Government of India organization, right, producing organization. All these people, even each and every word was taken proper care, and it was filed and it was refused. Yeah, hopefully that refusal order has been what you call it as has been filed on record. If you have got an opportunity, kindly go through it so that we can come to know where we should not commit mistake. That is the purpose behind that telling that basmati rice, Darjeeling tea. What had happened in Darjeeling tea? Initially, when the GE law was enacted, I am to share with you a very important aspect. How this law has developed. Initially, like trademark, we recognize a product based on the word and also logo, separately. The Darjeeling application was also filed by one of the firm in India, a prominent firm in India. At the initial stages, they filed 2 applications. But in GI, we are recognizing a product, only a product, not the word, not the logo. So the office took a decision, the Government of India took a decision to recognize only one as a Darjeeling tea as a whole. So these are all the development which took place during the registration process. So handicrafts items, blue pottery of Jaipur and all other things. Agra marble, Chennapatna tiles, very famous, Bangalore. And India is the only country where the product is also known with its quality. How? You see in South India, we have got a Tanjore, just like Chennapatna toy, Tanjore toys. Tanjore Talayati Bommai, head nodding toys. So that is Talayati is the quality of the Talayati means a head nodding. That is in our language. Talayati Bommai. Bommai is toy. So this is the nature. Then you come to the same Kumbakonam where filtered coffee emanates. Another pan, which we are going to see in our slides also in the due course. In that also, you can find Kumbakonam Kara Vettale. Kara means mirchi. It's a water. It's a taste. So along with the taste, it has been told. And then third, you take Kumbakonam Kara Vettale, Tanjore Talayati Bommai. Like this, with quality it is identified because it emanates from the ancient days. Ancient days, people recognize the, especially in India, recognize the products with its quality. Various parameters for recognition. One of the very important parameter also quality. So accordingly, you can very well say. And from your region, one of the best products. Well, yes, sir. Please. Any problem, sir? Can I continue? Hello? Hello?
Yes, sir, please.
Yes. So there is no problem?
No, sir, no, sir.
Yes. Thank you very much. Thank you very much. So, so the Moha silk, you see, it is a treasure of Assam, northeast of India, no match globally. But whether we can achieve to what extent it has to be. Even the RGA, people fail to put RGA. Is so much paining for me to tell before this August gathering. Nobody is putting RGA. RGA means, then the next question comes, RGA means what? RGA means registered geographical indications. So once it is registered, it is a registered geographical indication. It is as per law. Any product you take, most of the Indian products, you can find it is missing. Who is to train them? It is the duty of all. Everything rests in your hand, people. In your hand, the youngsters, those who are the pillars of tomorrow. The nation is requiring, wanting you to do something good to save the country from what do you call it as the duplication, deception, and what not. So, in this way, we will go all this Hyderabad biryani, Halim, Hyderabad Halim, then Bikineri Bujia. I'm not very familiar, or I cannot tell you that Bikineri Bujia, whether it is registered. I don't know. I have no idea. The question is, even more than 2 lakh, 3 lakh producers are there for Bikineri Bujia. And mostly it is, I should not tell before this forum, it is dominated by some of the very big companies. The whole issue is, even there is a provision under law, what do you call it as collective reference? File an application with some collective reference of some of the people, and then others as joining as an authorized user. The concept of authorized user also we will be discussing in the course of our discussion. So the next part is, what for this law? The law, there is no specific law governing geographical indication of goods in the country which could adequately protect the interest of the producers of such goods. That is the Bible, that is the Gita, that is the Quran. When we take the GA law as a matter of fact, what the purpose is, it should be able to, the association which is going for registration should be able to protect the interest of the producers of the concerned goods. That is the purpose. So then, misusing the geographical indication is also to be avoided. So protect consumers from deception, add to economic prosperity. I am going to highlight some of the products registered during in the initial phase. Because of today, you can say that sustainability, want of sustainability, it is my feeling, it is only my guess, it's only my, what you call it as, my observation, where you can find that consistency, sustainability, the quality, continuous maintenance of the quality, which is lacking in some of the very important products, though they achieved all goods immediately after the recognition. It is not a bad thing to tell you that if they can at any point of time, we can go for revival. So these aspects I will go in detail more when we go there. So geographical, promote the goods bearing geographical indication in the export market. Export market also, some of the products have achieved very good results. The Geographical Indication of Goods Registration Act 1999 came into force since 15/9/2003. So this registry is located in only one place at Chennai in India. There is no compulsion that people should file and get the recognition. It's purely an voluntary exercise, GA recognition. Who can apply? We will go. And method of filing an application, concept of authorized user, which is a peculiarity of the Indian law, is the concept of authorized user to protect the poor and for what you call it as the poor farmers, poor weavers, poor what do you call it as handmade, that handicraft persons and all that. That is the purpose behind the concept of authorized user and the registration process, how to go the registration and the importance of consultative group. That is the consultative group is a very prominent role in the protection process. When the consultative group is identified the right persons for the right job, then there is no match for that product to challenge anywhere throughout the globe. Then additional protection of notified goods. Normally, it is known as the TRIPS. Basic of TRIPS is certain goods of wines and spirits are only given the additional protection. Additional protection means champagne like, champagne kind whiskey, champagne like whiskey, champagne type of whiskey. So this type of indications is also avoided or prevented from using it. India as such has given a provision as for additional protections of notified goods. If Government of India tomorrow has given a notification claiming that the agricultural goods, industrial goods, manufactured item, handicrafts item, food items are to be given additional protection, immediately I would rather prefer. First, even today we have not recognized Khadi as a GA in India. It is it should at least, hopefully it will come very soon with all your great support and effort that we have to give as a mark of recognition, as a mark of respect to the first, to the father of the nation. And it is nothing but the exclusivity of India. No one can claim that Khadi is mine. It is the exclusivity of India. Such type of products are missing the recognition is really paining. So we have to ensure that we should go for such type of product and get the recognition at the earliest opportunity. We will discuss during our question and answer session those aspects to my understanding. So we have got two registers. One is Part A, consists of particulars relating to registered geographical indication. That is one who initiates the process of registration before the registrar of geographical indication. That is what you call it as the relating to the geographical indication. And Part B, another register, which consists of particulars of registered authorized users. The registration process is similar for both. Notification, 4 months period, waiting period, and all other requirements of the same for recognition of all these persons. Then, even an authorized user individually can take infringement action against the wrongdoers. That is the purpose of it. The registered proprietor and authorized user both can take infringement action. GA registration provides the authorized user the exclusive right to use the geographical indication. Monopolization of the market enables the products to control prices, can change premium prices, thereby enhancing the profit. It goes without saying. We have the next other slides are going to highlight you how it will fetch a very good premium provided if this tool of recognition is used in the proper way, the proper manner, the proper perspective. So then studies have revealed that more than 80% prepared, consumers are prepared to pay 20 to 30% higher prices. What else more you require for a product? When you have a wholesale deal with for a particular product with 20 to 30% margin, nothing like that. And all our rural products, that is what I'm going to tell. I have taken a pledge. You should also take a pledge, which I'm going to tell at the closing hours of mine, telling that you should start using only the rural products of India. Wherever you go, you develop the rural products, promote the rural products for their prosperity, in turn the prosperity of the nation as a whole. So goods they believe are having better qualities over other goods. So only when there is a uniqueness is there, we are going to recognize. So then I am coming to the live examples. One or two cases where I have got some data here and there. Pochambali Ikat was awarded the GA registration in 2004, first in textiles. The textile committee studies, you can see what are all the areas there is an increase in production, increase in sales turnover, increase in productivity, increase in employment, price growth, and increase in weavers' income. It goes without saying, when you have got an increase in all the other things, their income also. That's how the end result is the development of the rural economy. And increase in the customer base, that is what vital for us. And when the present day trend, as per the present day, we can go for an online sale also. So when you go for when the authorized users have got their net and selling it the global market, nothing like that. Nothing like that. How many products have developed their own website to promote their product with their RJ recognition? Count and tell me. To my understanding, I find something is missing. So these are all nothing but to provoke you, your thought process. Lot is lacking with us in respect of recognizing the gold mines of India, the treasures of India, which will give you a lot of pleasure. When you get involved in this process, there is no match to it. Even after, this is my first talk after my exit from the GA register after 12 years. Even now, I feel I'm part of it because such a level, India's growth, I can guarantee you, I can challenge anybody. If we put everything the rural products, mostly the tribal products, we are giving only the Cadbury chocolate. You take Cadbury's. No one is giving the Woody chocolate, which is a homemade product emanates from that particular area. Even I feel that as whether it has been recognized under GA or not. Where the folly lies, we are not able to see our own family, whereas we are inviting others and telling them, you are a great man. Kindly, we have to promote our own product, which others are doing 200%. I'm telling you, not 100%, 200%, which is that is where we are lacking. Saris woven in Kota Doria, where it is from Kota, where you can find the increase in income from 17% to 2,000 within a span of 3 years, 3 times increase. It is a study. I am not telling. It is a study. Increase in income of master weavers, increase in employment. Famous retail chains and design houses now approaches the modern weavers. This is the beauty of it. But the modern weavers should not be allowed to be purchased by them. That is also one aspect which is, though not within my reach to debate, But all those aspects, when money comes, these people will start doing the work for others. Natural. So we should enlighten them that today you may get some money, but tomorrow you are the master. Really, you are the master. Kindly don't leave. Kindly be within your limit, within your territory, and develop your own products. Women now claim that they have more respect at home. This is very vital, considering the respect given to women and are able to send their children to schools and colleges. It's related to the rural area. Now, I told you, even we have not reached the triple four figure after even a time span of 200 years. This is the data. Hopefully, the data available from the GA registry as on date. But how many applications have been registered? 370. Agricultural goods 109. Foodstuffs 23. More than 2,000 foodstuffs are available in the rural package, to my understanding. And the basic requirements of law, that being what we debated earlier, and I'm going to show you a slide with the authenticity to tell you this is how to go about. Even if the courts fail to recognize this, we can tell the court, this being the law, governing law, you should reconsider your decision and ensure that the recognition is given. So, agricultural goods 109, foodstuffs 23, handicrafts 214, manufactured item only 22. Every state has got not less than 500 to 600 manufactured items from the rural packet, where either the production or processing or the preparation without involving the raw material is taking place. At least let us have a 50%, 200 to 300. How much would have been there in the GA registry? Who is to blame? Who has to take steps? It is time that the universities are taking a giant leap in this exercise, where we can develop the nation within no time up to an unimaginable level. So applications examined 120, pre-examination stage is 109, refused is 53, advertised is 46, abandoned is 28, withdrawn, merger, opposed, total. I am concerned with this aspect of refusal. It is only an overall, my feeling I'm sharing with you to my little understanding of this specific law, what we are recognizing. There was a very big discussion. There was a very big seminar in Delhi during our time in 2006 or 2005, if my memory is correct. There was a complaint to Secretary Government of India that all the products filed in GA registry has been recognized by GA office. Then I was with my boss. My boss was not answering. But I started answering immediately. He asked, you please kindly tell me. He was kind enough to patiently hear my argument. What is the difference between the GA law and other laws? Patent, your own imagination, your own intellectual capacity. Trademark, you have your own mark developed by you. Design also like that. But what is in existence is recognized in GA. That too with special emphasis to heritage, customary practices, heritage, customs, the prevailing practices, which forms the basis for the development of that particular product has been recognized. Then, when we have got a study and when we are able to prove that the nexus is there between the product and the application file, what is wrong in recognizing? Then immediately we are happy to tell our this was considered and recognized. Having considered that thing, Now I am finding this 53 refusal somewhat, to my understanding, it is on the higher side. What is lacking, which I have to do my own work, and I request what do you call it, as type of research work by people. All those refusal application you take, and we can find where we lacking, and we can guide others also. These like this, we have got enough. So many issues are there which we can go on discussing. This is what, but my two important specific issues are 775 is not the correct figure. So I wish, and with folded hands, I request this August gathering to go for more registration in the, and ensure that recognition is given to the products. Then I'm going through one or two slides in a very speedy manner. For want of time, it is already said. I don't want to take much of your precious time by boring certain issues which may like may not like. So total chapters are 9, sections are 87, preliminary are 1 and 2, and conditions for registration relates to 3 to 10, procedure from 11 to 19, effect of registration 20 to 24, miscellaneous items 57 to 87, offences and procedure penalties with 37 to 54. This is not there now. Appeals to the appellate board is not there. So it is now. Hopefully it is how we have to file only in the High Court. Rectification and correction of the register by 37. Special provision relating to trademarks. Once it is a GA, you cannot go for recognition under the Trademarks Act. So those are all the special provisions, 25 and 26. The entire act covers even criminal actions, you can say. Now, I'm coming to the crux of this entire proceedings. You call it as our debate. This is what we are going to have a detailed deliberation. Applicant representing the interest of the producers. In this connection, I would like to highlight when we, what we call it as, when we go for Tirupati Laddu recognition, it is a trust. File the application. Whether a trust can file an application, we can say. We will see in this definition itself. The question arose, trust, trust is a single entity, whether it can file. So, interpretation of statute was shown before the Honorable High Court. The interpretation of statute revealed that single can be, as per requirement, can be used as a plural, plural can be used as a singular. So, with that, we have come across that particular objection that it should be filed by a single producer. But nowhere an single individual can file an application. That is where the trust is not by an individual. So these are all the issues you will cherish yourself every moment when you go for involve yourself in the GA registration. Who can file? Association of persons, producers. So producers, basmati producers, some rice producers, any organization, authority established by law, under the law. So these are all the persons entitled to file an application. So a company can file, a trust can file, the producer group can file, the association of persons can file. Or then, what is the problem? To file an GA application which emanates, provided with the nexus with the territory, region or locality. I'm repeating to give emphasis, to give you a stress, to make you feel that I am on the right track. So then coming to the types of goods, Sky is the limit. Agricultural goods, natural goods, industrial goods. I would rather prefer to tell you, in case of industrial goods, Jamnagar is an industrial-based goods. Yeah, to my understanding, where the manufacturing activity of production, processing, and preparation is taking place, and it has got a high reputation internationally, and quality standards are 99.9% quality parameters it is established. Suppose in Jamnagar we recognize it's all my personal view. People may have different perceptions. Yeah, the ultimate deciding authority is the courts of law. Where what is missing in India is the views, unless expressed by court. I don't agree with any person's views because I may have my own view, you have your own views, but nothing wrong in attempting. Even an Indian has to make an attempt in the best countries of the world, USA, Chakravarti sir, for microorganisms. He went up to the person. I feel proud in telling that a person from India went up to the Supreme Court of America to ensure that recognitions of microorganisms. Hopefully, the Chakravarti. I'm wrong. If I'm wrong, the name, kindly excuse me. But somebody from India has gone. Hopefully, it is Chakravarti. So, such being the situation, in India, why we are coming as and blocking the development process? Let the court decide. After all, it is 10,000 rupees. If it goes 10,000, if it clicks, it is 10,000 crores. Maybe 10,000 crores, 1,000 crores, 1 crore, 50,000. No problem. For a small manufacturing producer, a tiny fellow who is preparing a toy, 5,000 is a big money for him. Why he should go and leaving his family tradition of that, what do you call it as, hand God-given gift to go for other employment? Think for a moment. Think for a second. Who is to blame? I feel there is a role on my part, my also. Like I take the privilege in telling you also. Because we have got a very big role to guide them properly, to ensure that they are taking a proper steps in recognizing those products. That is what is missing. So then agricultural goods, natural goods, industrial goods. So kindly allow the products to file. The big issue with Jamnagar refinery was, I was given left and right by the ministry at that time. How you accept this application? It is all these things, parameters are fulfilled, we have recognized. But one basic problem with that application was we have recognized, we have notified this as a, though the consultative group took a decision to remove that Reliance logo and convert it into a Jamnagar application, Jamnagar oil, Jamnagar diesel, only then it will go. It is not in the Reliance product, it is a Jamnagar. Jamnagar application mooted by the Reliance having 99.9% quality parameters assured. If tomorrow another company in that region, for example, SR, for example, only I am telling, SR or some other company who are all in the same line are able to make 99% of that parameters proof, then they will also become eligible to call it as a Jamnagar. It is certain parameters and it is nothing but a tool to promote the prosperity with the premium. This is what the purpose behind the law. This is what the objective of the law. This is what the answer to everybody. That is the purpose for which we are going for recognition or registration, as the case may be. So, this being the reason, this being this thing, so you can find there is no bar. Now, who can file an application, provided the interest of the producers. Even if a company's shareholders' interests are protected. We have got a case. They asked me how you accepted. Already it is recognized. Mysore sandal soap, which has been recognized. So like this, so many issues when we discuss, when we debate, when we come across, we have to have so many plus issues for and against. Then finality will have to leave it to court of law. It is not that your English which has to speak. It is the finality of the court order that has to be. The very big problem with India in the open forum. Now I am retired, I am telling you with all open fairness in my mind. If my English is good, everything is fine. For even for a top brass, it is not that. It is not that. I respectfully differ with that view. Your English is good, we appreciate. But we feel English is a foreign language for us. Our own languages, there are a lot of languages in India where we recognize, we respectfully accept English as a common language for everybody to have an interaction because of the local language problems. So, if I start writing a beautiful English in my own way, tomorrow an article, it will not come. Immediately that will show. Then they will think that what they have done is wrong. We have to object, we have to object. Where we have to protect, we have to protect. That is the purpose of this law. This law is an excellent law, having a wide coverage. Sky is the limit. I'm repeating, sky is the limit, where we can have excellent way of interpretation, excellent way of method with which we can cover a lot of products. Filing an application, preliminary scrutiny, data entry, all these are all big. Then the consultative group, what is the purpose and its action? The eminent persons in that particular field, 7 members maximum, eminent persons in that particular field are to be known as the consultative group members. Those people will discuss, debate, deliberate, and decide how to go about in an application. I would rather feel very happy to inform. It is not to be told because tomorrow it will be a very big issue in Kerala. Even in Nilagiri, what do you call it, as tea application, when we discussed the area height, 1100 feet, up to that level only, you have got a quality which is to be recognized as what you call it as the Nilagiri tea. Whereas the Kerala side region is above that level, it appears. To my understanding, it is my refreshing memory, where 3 experts were from Kerala. But the others have convinced that we have to go according to the rule of law. They agreed. Such is the transparency and working system of Government of India. And that application was allowed. Even today you can find the height to which it has been recognized. So those are all the critical issues which will come, which will be debated, deliberated, and finality is arrived at. The another important product is what you call it as that very important tribal product, coat pot sarees, where history, there is no history for that product because it's a very big tribal region where then we want to see that that product is recognized. How to go about it? How many people are above 80 years are residing in this tribal village area? I asked, sir, we have got, Nandu, we have got more than 100 people. Sir, I will complete it within 10 minutes, the remaining things. And 10 minutes we will have a deliberation.
Yeah, sure.
7:30
Sure.
only is my limit. So I think there is some this thing. So
Yeah. Please. Yeah.
yes. So because I want to tell certain important issues. No, sir. About the Kotpad region, the Kotpad region is where then I asked our people, the consultative group members, sir, law permits when we don't have historical data and documentary proof. As per law, we can call for an affidavit from age-old persons of 70 and 80. Keep it as a record. To my understanding from my childhood. So 80 plus 80, 150 years back. Our requirement of that history data, will it not fulfill? Then it was with very great pleasure I'm telling, the members have also accepted for that. With that affidavit from all those persons, we recognize that Kutpat sarees. Such a proactive role is Government of India is taking. Then why we should not go for recognition is the issue before everybody. Then geographical indications, the entire India, where we go for it, that is what the next is. Then I am coming to the legal angle of how to go for recognition. It is sufficient in order for a product to have geographical indication, that is production and or processing or preparation takes place in that defined geographical area. It is accordingly not necessary that the raw material originate from the geographical area concerned, provided that the finished product is, example, processed in that area. How lucid the law is. We have to exploit it. How far we have exploited it? This is a big question, $1,000,000 question, which we have to answer. That I will go to the other part of it. Even for that only I told, for Jamnagar example, where the legislature uses in a new enactment words, phrases, 3 parameters as far as GA law is concerned: quality, or reputation, quality and reputation, it is not there. Or so individually, each independent parameters you can claim a right. So when you have got a quality, you can go for a GA. When you have no quality, of course, GA should have a quality. For argument's sake, I'm telling, assuming without accepting, your product is handmade, where you have got only reputation. You have to develop the quality. You file it with your reputation. It is for the consultative group and other GA registry, whether it is according to law or not, they have to decide. Then the question comes, even if you feel that they are at the wrong end, there are other forums, High Court, Supreme Court. Why should we? It's a community right where everybody's interest is protected. The whole issue is big fish using your or exploiting is avoided. So we should ensure, we should promote all these things where the legislature uses in a new enactment words, phrases and other formulations which have appeared in earlier enactments and which have been the subject of authoritative judicial examination and clarification. Quality would have been debated, discussed, deliberated in so many decisions. In independent India, over more than 7 decades, we have to collect, we have to document it. We have to ensure that all those documents are used for the promotion purposes, earlier enactments and clarification. Then it is to be expected that the legislature, in deciding to use the same language, was intending to have in the new enactment the same meaning that the courts decided it had in the old provisions. It is without saying the courts will accept. How far we can do? We can do wonders. We will be discussing in our question and answer session. This is also the another area where you can say about the origin. For want of time, I am skipping some of the slides. I am telling you from northeastern states, how many wines and spirits are coming. The locality made popular alcoholic drinks from northern side, India. Abang, made from all the tribes. Arunachal Pradesh, Zumai, made from Boda tribes. Very famous, very, very famous. But can I get it in southern part of India? No. Double no. If you allow me, I will say triple no. Why? Because of want of proper exploitation of those things in the form of by virtue of what you call it as in law. We can make all these things, all these regions flourish with their products, produce fermented alcoholic drinks, villages, and all these are all where others are doing, we are lacking. Medicinal plants. Kerala is the best area, and Northeast is a gold mine for medicinal plants. I have given some of the examples. You can very well go through it. For want of time, I want to discuss, but other things are more important than this, which I will discuss so that my session can be concluded before the scheduled time. Animals and meat products. Excellent products are available. Food items, no match. No match with India, but we are lacking. Other animals and animal products I have given, you can go through it. Pan, I have told. Banarasi pan. Whether it is registered, I have to see. And Calcutta pan, your Calcutta pan, whether it is registered. Tomorrow you can develop it, file an application, get the recognition. Kumbakonam pan, which is not registered. And like this, I'm going to show you a slide. Within a radius of 150 kilometers, the soil, the nature, the size, the color, the fragrance, the specification, the quality, all these things are different with regard to the article product which has been recognized. 3 products have been recognized. I have got that slide which I'm going to show you now. So then in that situation, in that prevailing conditions, what is lacking for us to file the application? That is the issue, very big issue before us. Then the Gangajal, it goes without saying. So for want of time, I will skip all those discussion of the slides. Then coming to this very important products. At the time of bringing this application, this was during my time, this got registered. Who came for filing this application was the former registrar, Mr. Most respected ex my guru, Mr. Acharya. He came to me, very sweet talking, soft spoken person. So he told me, Natarajan, it is from my area, and I want to see that it is registered. Then we have our own, because it is the development process. Then we have to cross through so many hurdles, and it has been recognized. 2 months before or 3 months before, after my retirement, that young boy who was introduced by me in the GA arena, who is playing a key role in India today, going everywhere, even in all the parts and making all this. I feel proud to tell you that our people are flourishing like anything. So that that very big scholar, today he is a scholar. So he sent me a message from Times of India showing that woman folk is making all this Puneri Pagadi, and they are enriching themselves with a lot of money. My simple question is, definitely, to my understanding, there will be another, if not Pagadi, it is, to my understanding, I'm telling a slang quote, Jigadi will be there in what you call it as in the West Bengal. You develop such type of products. These things, if we are not getting it in these deliberations, as a mark of respect given to literates, it is not given to ordinary people. When eminent scholars are coming, excluding myself, because I am not in that category, don't think that I am telling my own, blowing his own trumpet. So, These things you can give them. It's a pleasure for us. It's a pleasure for a poor woman for which is preparing this pagadi. And it is a mark of respect to that area. Tomorrow it will be followed by other countries also. Pumuneri Pagadi will become popular even throughout the globe. That's how the development process goes. This is one important product which I want to tell you. Like this, I can go on telling so many products. Already my time is running out. So the next question is Tirupati Laddu. I asked, so many things have come in paper, but as a matter of fact, we are after recognition. Today, it's recognition. It has got a global recognition, claiming that it is the best GA recognized. So, such a level, I asked a simple question. If Tirupati Laddu has no recognition, which product has got the reputation? What is the purpose of this enactment of this law? Even I spoke to the advocate who was representing, because I was in the other side that time. Today, had I been there, I would have wear my coat and gown and appeared before your lordship and told. But fortunately, I have represented to the council. So, not only it is having a reputation, it's a method of manufacturing process is within that. And you can find the latitude and longitude is nothing but the kitchen of the Tirupati, that where the laddu is prepared. So such a level, the precision is there by Government of India when we recognize the GA products. Hats off to them. Hats off to my family where they are doing an excellent job and as a proactive role in promoting the rural products. Then coming to this, another important, the Coimbatore wet grinder, which is unique to this. When you put the pattar in your mouth, within 2 minutes, you will see that kara kara kara, there is a sound. All this will go. Even a mechanical influence of power, you can see that is grinding. That is the peculiarity of product. That is the peculiarity of the nature. That is the peculiarity of that stone, which led to this recognition. USA had a special section of seminar in Coimbatore for this at the time of recognition. Whether we are using RGI today for this type of products, and when I go for the Mysore sandal soap, I think another 5 to 10 minutes for me. So I will complete it before that. When I go for Mysore sandal soap, Dhoni was upcoming. They enter into that brand ambassador for 70,000 rupees. It should not be left it open. But they have told me it was very early stages of Dhoni. Then they told Dhoni will see that Mysore sandal is promoted. Then with all respect to Dhoni, sir, I beg to differ with you. I told him, Dhoni's fame of Dhoni is short-lived. Today, the another captain is there, he is popular. His fame is also short-lived. But GA's fame is everlasting. The tag goes on and on and on. So that we have to take into consideration. This is the area within a radius of 100 kilometers. You can see all this different. This is Udupi, Mysore Malli, and Hadahalli Malli, if I am not mistaken. Within a radius of 100 kilometers, you find. Then how many products, agricultural products you can find? This is a very important thing for your what do you call it as for your thinking. Then coming to this Payanur Pavitra Modram. Payanur Pavitra Modram is a very big issue, which is now two groups are fighting. The finality has not reached. But my thinking is the registrar is the ultimate authority to recognize or dismiss. Now it is with the collector of that to file an application. How we can file and what way it can be recognized, all these are all the issues which I want to be out of this. But to my understanding, when an application is filed, it is for the registrar's duty either to register it or to deny it. This is what the simple language, as far as to my understanding, the law is. Then the next question is Kadi. It is really paining to tell you, in spite of 17 years of existence of law, Khadi is not recognized as a GA. And I wish with this movement started today, it is not only recognized as a GA, it is with God's blessings. Let that additional protection be also be notified for Khadi as a mark of respect to the father of the nation. Then this is what this issue I discussed already. All other skips things are there. You can see collective mark and other things. To conclude my address, I have taken a pledge today. I, V. Natarajan, hereby take a pledge to what? To promote and develop the rural products of India in all walks of my life, thereby promote the nation building activity. I invite you as a scholars, as eminent professors, as big personalities to join in this noble cause and thereby develop the national building exercise. I once again thank you everyone for giving me an opportunity to share my feeling in respect of the rural development and the GE law. Thank you very much.
Thank you so much, sir, for that extremely engaging, interesting, and visionary talk. I now open the house for discussions. If any member in the audience has any question for Natarajan, sir.
Yeah, good evening.
Sir.
May I ask a question?
Sure, sir.
Okay. Good evening, sir. It is really a golden opportunity for me to hear you. And when you were there in a registry and I heard your many illustrative, the presentations earlier. Today, you have given the different kind of insight of understanding GI, which is happening everywhere. But I have two questions, sir. The first question goes to you. Like recently, you are aware of that one particular GI, which is still very, very confusing for my basic understanding of GI. That is a Rasgulla case. This Rasgulla is a product, is a particular region at a particular place of a particular reputation. In previous time, maybe the Rasgulla was produced in West Bengal or elsewhere. Convincingly, it has been admitted by the public at large over statutory protection that Rasgulla is a product of West Bengal, and we have given the GI at the beginning of the Rasgulla, which is the product of Bengal. Now, a particular state, a group of people of a particular state came forward challenging that GI, and the proceeding started. And at the end of the proceeding, for a kind of amicable settlement or giving the GI in a enlarged form, it is Rasgulla of Odisha and Rasgulla of Bengal. Now my question goes to you, sir. If somebody is, the GI is basically a kind of protection which will definitely help us to earn the foreign economy, that international market. Suppose I export the Rasgulla with a GI tag that this Rasgulla is from a particular region, rather, for example, from Calcutta, and taking the tag of the Rasgulla, GI of Bengal, the similar Rasgulla may be of the different region, but the taste is the same because most of the Rasgullas are nowadays appears to be the same because there is no definitive speciality for formation of the Rasgulla. That came on my mind because in international market, this protection of GI of Bengal Rasgulla or the Odisha Rasgulla will be diluted in the passage of time, whereby the question of protection of the GI or the idea of protecting the GI will be defeated. So how do you feel about this particular GI, which is very, very, the borderline GI, the case in India, rather. So I would like to hear your valuable comment on it. But my next question goes to recently there was a speaker from Bangladesh, and he was talking about some other things, and our Dr. Singh Saab is here. Means like he also raised that question called Hilsha fish. Sir, I'm giving you the one example. I'm sure you heard about this particular the fish called Hilsha fish. It is basically a biological product which is being known as that particular Hilsha fish, and that is and it is a particular the area this called Podda Hilsha. So this like the Podda Hilsha, it is a river. It is a part of the river. The same river. It just came out of the Himalayan region, and it flows on the the soil of Bengal, rather soil of India. Then it passed through the Bengal. Then again it came to partly in India, and then just submerged to the Bay of Bengal. Now the question is that if tomorrow morning, I do not know whether they have already filed GI or not, because after us hearing the question of Dr. Singh, I might be, because I'm very close to the Bangladesh nowadays. So I will try to find out whether they have filed a GI or not, because so far I know this GI is not that strong. But however, if they take the GI of that Podda Hilsha, that particular fish, that particular Hilsha, because you see, whatever the GI as far as it is concerned, it is a static natural product. Maybe the Darjeeling orange, it is particularly grown in that particular region. It doesn't have that kind of character of the self-mobility. But this product, this biological product, it has its self-mobility. So therefore, that particular fish, which can flown from one particular region of the river, it can reach another particular region of the river. So in that case, do you think it will be a particularly very controversial? Well, this is a Rasgulla case. It is within the India. We could have amicably settled and giving the 50-50 kind of the case that I feel, because I have noticed the whole proceedings. But in that case, if the Podda is getting the kind of the GI, do you think India can combat against such kind of the GI in an international forum, and they can also take that particular GI into the 50-50 form? What is your comment on it? Because I find that both the GIs, this particular product has the same kind of human confusion as well as conflict of the GI, understanding of the protection of GI understanding. So please, sir, give me your valuable comments so that it will help me to understand and or can remove the confusion in my mind.
Sir, as regards your first question, whether the Orissa Rasagulla and Calcutta Rasagulla, the whole issue is, even in our GILA, because these are all the issues which for want of time I have not discussed. It is a territory specific, area specific. When we go for GI, it is area specific. In olden days, the Orissa would have been a united part of the West Bengal. It would have been, I don't know. So in that situation, it would have been developed. But when we file an application, we should have filed an application calling it as Calcutta Rasagulla, covering that entire area, so that our identity of Calcutta Rasagulla is not lost. But unfortunately, when I heard this, I was taken aback because it is my personal view. Of course, uh, once a compromise is reached, we have nothing to say. It is only the Calcutta Rasagulla. And unfortunately, in our provision, there is no, to my understanding, there is no provision for extension of area. If we have got an extension of area provision in our law, then we can extend that area with a sound proof from with the earlier historical data and other information. We can extend that area and allow the application so that this type of problems can be sorted out. Kolhapuri Chappal is a very big example for this. So, like this, we have to discuss lot of issues and covering a wide spectrum of area. To my understanding, that recognition, how far it is right, is still a question, debatable issue. Because definitely, to my understanding, the Calcutta Rasagulla's dilution is there. It is my personal view. There can be only one Calcutta Rasagulla covering the entire area. That may be Orissa, that may be Gujarat, that may be other areas. I am not going to that part of it. But when you say Orissa Rasagulla, then it is like calling basmati as a basmati of India, basmati of Pakistan, basmati of all these things will come. So these, now I am out of government, so I can share my views. It is my personal view. Once they have told me that we have recognized the Orissa Rasagulla, fortunately you have taken up that issue also. To my understanding, it is nothing but a dilution. As regards your second thing, to my understanding, it will go under the provisions of homogeneous geographical indication. In two areas, there are specific. Like example, India has recognized both Peru and also the another country, the neighboring country, for their that drink. What is that? Peru ka bahut bada whiskey hai, uska naam hai. So both these countries we have recognized, and a common understanding it is noticed from that record they have recognized. So to what extent it is coming in our area, that fish will reach 50 kilometers radius, 80 kilometers radius, identify that area and file an application in India, get the recognition in India for that, and go to the this Bangladesh and tell them that we have already recognized like this. You recognize ours, I recognize yours. This is one of the ways of possible solutions. I never say that it is the right solution. It is the way of finding a solution to a problem.
Okay. Thank you, sir. Thank you for your.
Thank you, sir.
Thank you. Thank you so much, sir. Does anybody else have any questions for Natarajan, sir? Otherwise, I request Dr. Rakesh Kumar Singh, our Dean, sir, to make his final concluding remarks and also to extend his vote of thanks for our speaker, Mr. V. Natarajan, sir. Sir, over.
Really, sir, we are very much overwhelmed, and basically, I can tell you that on behalf of all my colleague participants, now there is no confusion or any question in our mind with respect to geographical indications. The way you have presented the whole thing and you have made the things clear before us, we are very much thankful and grateful to you, sir, for devoting your very valuable time and gracing this very occasion. Sir, thank you very much, and really it was a very thought-provoking, and so far as a number of ideas we have also developed so far as with respect to geographical indication. And I tell you that, sir, we are also taking that we shall be also emphasizing on Make in India. And definitely, sir, our university is also located in a rural, so far as place, it is adjacent to Calcutta city. And definitely our researchers and erudite scholars, they are also doing a lot of things with respect to development of research in this very area. So thank you very much, sir. Please accept so far as our thanks, and definitely, sir, we shall be inviting you to our university as well. And thank you, sir. Thank you very much.
Thank you very much. I'm grateful to you for giving me an opportunity. It's all credit goes to our advocate Sarkar. So
True, sir.
he is the man behind, because he is the key man to tell. And such a big event you are hosting with sir, it's a very big thing, event, a mammoth effort for which we bow before you. Hopefully, more applications will come for the betterment of country. Thank you very much.
Yeah, true, sir. Basically, one thing just I would like to put before this very August gathering, that with this very international refresher course, we are also doing a social awareness program with respect to intellectual property rights. Thank you very much, sir.
Thank you. Thank you, Sarkar Sahab.
Thank you.
Thank you so much,
Thank you,
sir.
Thank you. Thank you very much,
Yeah,
sir.
thank you, sir. Our ma'am is Alferia ma'am is waiting.
Yes. It was indeed a privilege to listen to Natarajan sir. I will make a quick announcement in between and also repeat the announcement in the end of today's program again. The announcements go like this, that tomorrow we have our valedictory and closing ceremony, which means tomorrow all of us will join in at 5 p.m. and the session starts at 5 p.m. IST instead of 6. Tonight by 9 p.m. one has to submit the objective test, which is why the assignment, and tomorrow is the objective test, which is why I'm mentioning it right now, because by the time we close today's session, it might already be 9 p.m. So we have about 1 hour, 15 minutes in hand. In case anybody has still not submitted the assignment, please do so, because sharp at 9 o'clock, our Google Classroom will stop taking any more assignments and the form will freeze. Tomorrow we have our second and last weekly test, and tomorrow we join in at 5. I also take this opportunity to extend my thanks to our knowledge partner, Professor Vishwajit Sarkar, who has done way beyond and above as per his capabilities in order to help the Neotia University, the IP cell. And tomorrow we will have a proper vote of thanks, but it is indeed imperative on the part of the organizers to keep mentioning his contribution, without whose contribution it would have become extremely difficult to hold this 2-week-long international refresher program. I now straight away come to the second session of the day, and we have with us an extremely august speaker. We have with us Madam Eleftheria Papadimitriou, who is a lawyer, mediator, trainer, and ODR system designer from Greece. First and foremost, Madam, did I pronounce your name correctly? If I did not, please pardon me.
Yes, very correct, I may say, because it's quite difficult, the Greek name, and most of my foreign colleagues call me Ria, just, you know, the short version of Eleftheria, and it's a bit easier. So whatever, it's easier for you.
Okay, thank you. We will endearingly call you Ria, Madam, towards the later half of the sessions.
Thank you.
But I will introduce Madam to the august audience now. Dr. Eleftheria Papadimitriou is a legal scholar based in Thessaloniki, Greece. She is a practicing Supreme Court lawyer and is an accredited mediator at the Greek Ministry of Justice, ADR Group of UK, INADR USA. She is accredited trainer for mediators at the ADR Group. She is an ODR system designer and also an e-commerce consultant at the spin-off Aristotle University of Thessaloniki, Greece. She is the founder of Eleftheria Papadimitriou and Associates law firm, a boutique law firm specializing in corporate law with focus on IT, IP, and privacy law. She is the founder and general director of START ADR, a non-profit institute for alternative dispute resolution for the promotion of ADR-ODR through mediation, arbitration, and negotiation. START ADR is a training institute and an accredited ADR body of the European Union ODR platform. Her fields of expertise are information technology law, consumer protection law, e-commerce, intellectual property law, and privacy law. She specializes further in medical law on legal and ethical issues related to the use of technology, and especially artificial intelligence in the medical field. Ladies and gentlemen, I take the honor and the privilege to introduce Madam Eleftheria Papadimitriou from Greece as part of the second session on the 11th day of the 2-week-long international refresher course. Madam Ria, over to you.
Thank you very much for your kind invitation. And of course, I would like to thank personally Professor Dr. Rakesh Kumar Singh for his kind invitation, and of course, his university for this, I may say, extraordinary presentation and all this program with the International Refreshment Course and all these initiatives that are very exciting, I may say, and it's an example for us and for other universities as well. I want to congratulate him for all his effort and his very good job. I really admire him. So without further ado, I will start my presentation. You will excuse me if I am slow on a few moves because I'm most familiar with Zoom. I have a presentation for you. I think I can share my screen with this button. Let me, if I do something wrong, you may correct me. Can you see my screen?
Yes, madam, it's coming.
Yeah.
Yes, we can see.
Oh, okay, because I can see only my presentation. I will start my presentation. So, as you can see from the subject matter, and you have already read about on the program, the subject matter of my presentation will be alternative dispute resolution in the field of intellectual property rights, and especially I'm going to present you the WIPO Arbitration and Mediation Center. I will skip the intro because it was more than enough what you kindly said for me. So a few words about WIPO Arbitration and Mediation Center. First of all, what is the mediation? What is the center? The center, of course, we have to take the historical grounds. It's based in Geneva, Switzerland. It has been established since 1994. So it has a long reputation and a long run in the field of dispute resolution in ADR and recently in ODR, in the field of intellectual property rights disputes and technology related disputes. Since 2010, it works its office in Singapore at Maxwell Chambers, and we can say now that by now 20 years, the center offers a high quality, if I may say, ADR services. So, what are the disputes that we can submit to WIPO's Arbitration and Mediation Center? If I may, I will take two main categories of disputes before going further to the most in more detail to the disputes, to the IP disputes. I will say that there are two kinds of disputes: the contractual ones, related, of course, to IP rights and technology disputes, and non-contractual disputes. As we already, a lot of us may have seen, the contractual disputes from our experience as academics or lawyers in this field mainly concern patent and software licenses. We are going to see in the next slides how these disputes are disputes that are more frequent and other are less frequent. We're going to see the frequency of that. Also, contractual disputes may concern trademark coexistence agreements between trademark owners that may overlap at a certain extent, and at a certain extent they may produce confusion to consumers, and these agreements make the use or even registration in some cases possible. So for the owners, of course, there are issues arising in that kind of relationships. Also, another category of disputes that we may see under the contractual disputes are disputes that concern distribution agreements, especially in the pharmaceutical industry. And if I may say, the following years, we are going to see later on the disputes that the center has dealt with the past years. I think we are going to see a lot of this kind of disputes the next following years and have a rise in that field. Due to the pandemics and the vaccination and all that, I think we are going to see a lot of disputes there. Also, there are contractual disputes that are concerning research and development agreements, especially not only in the field of the technology, which is also in the rise with the proliferation of e-commerce, internet, and AI, if I may say, but also in the medical field in general and pharmaceutical more specifically. And the second category, as I mentioned before, are the non-contractual disputes. Here we find mainly infringements that have tort-based issues that we have no contractual base. Infringements, we are going to see more in detail what infringements we may find. In more detail, as I said before, we have licensing disputes that have to do with licensing agreements. That agreements may concern trademarks, which with e-commerce and all this shift from to the virtual world have proliferated, of course. Trademarks, the trademark registration, and from my experience as a lawyer and as academic, I have seen that there is an increase in filing, especially the last 2 years and during the pandemics. For obvious reasons, we are going to say about a few things about the trademark and the domain names and what are the issues there. Also, there's a very high percentage of agreements or disputes arising out of patent licensing, especially in the field of technology, mobile technology, and pharmaceutical and in the pharmaceutical industry. Also, we have copyright disputes, disputes over software in any sectors across sectors. Another category of disputes that give rise to filings to the center, to the WIPO center, are research and development agreements. And especially in the years that to come, we are going to see also an increase in that, because we have R&D even in countries such as Greece that are not traditionally in the field, but we have developing issues and environments as well. To see a lot in this area. Just let me say that in Greece, that we had not, for example, very much R&D going on. We have Pfizer hubs, we have Tesla hubs, and Microsoft, of course. So even in countries that traditionally don't deploy and develop R&D structures, we see a flourishing in that field as well. So I think my opinion is that we're going to see a rise in this field as well. Of course, there are disputes that have to do with the technology transfer agreements, distribution agreements, franchising agreements, and information technology agreements in general in all fields. Another category, very, I may say, interesting for me, is data processing agreements that give rise to disputes. because as we can see, and from the GDPR, enormous impact all over the world, not just in Europe, all over the world, over US, China, and India. Data are the fuel, as most of people say, of the next century, and the gold of the next century. So we are seeing a lot of this of this area, and of course the disputes arise as well. Another category of disputes we can find in joint venture agreements, especially important in these days, and in comparison, of course, with R&D agreements that has to do with the financial support of all the projects and all the research, even in universities, not just in the private sector and the big and large companies, tech companies, but also in the private, in the university or in public sector. We find these agreements, financial agreements, that very important, and that they may give rise to disputes. Also, very briefly, there are consultancy agreements that give rise to disputes, art marketing agreements, and of course, digital copyright agreements. So we are in the year of the digital age. So these disputes are a sine qua non in dispute resolution. We are going to see them in any way. Finally, a few more categories, very famous, I may say, TV distribution and format agreements that give rise to disputes. In the area of film production, in the copyright collective management, when it has to do with copyrights, and especially these days that there is a general reformation, at least in the European level, of the equivalent of the respective legislation. So there is a lot of interest in these disputes as well. And of course, cases that maybe traditionally had recourse to court litigation or are in the middle and pending in courts, they can also be submitted to the WIPO, and we see that all these years be submitted to the Arbitration and Mediation Center. I think it's a very good example of what we can see under the WIPO Arbitration Center in terms of dispute categories. As I mentioned before, and you can see this is from the WIPO side, I have borrowed a few infographics for a better understanding, visual understanding of our issue. As we can see, the biggest portion of disputes concerns patents, as I told you before. 25% we can see here. Disputes that have to do with cross-licensing, infringements. This goes here, not just the contractual disputes I've mentioned before, but also the infringements of the non-contractual base. Ownership of patents, patent pools, very interesting, and specifically in the field of mobile industry, the patent pools. We know we have read about the battles between Apple, Samsung, and these giants of mobile technology. Also, there are on the rise R&D, as I mentioned before, and tech disputes, transfer disputes, and royalty payment. Of course, there are issues there. We can see that almost at the same level of disputes that we meet at the WIPO Arbitration and Mediation Center are disputes concerning trademarks. Of course, they're proliferating more than ever. There are file registrations, and of course there are oppositions as the EU WIPO also states when you are, I don't know if you have any experience, but IP lawyers should perfectly will know that one, according to UIPO's advice, one or instructions, 1 out of 5 trademark EU trademark registrations are opposed. So there is a lot of competition on that field, and of course, this competition brings disputes on the opposition level, or even in the field of or afterwards when we have revocations. Another, as we can see from the infographic, a great deal of disputes we have concerning copyright. Of course, if we had to guess, it will be in the field of media, film productions and TV, where the stakes are high, the financial budgets are also high. So there is a lot of interest there, as the producing companies have given a great deal of money to the copyright and other IP rights. So they want to protect them and fight for them. At not so much level, we found disputes that have to do with information technology in general. As I said before, in the field of mobile apps, outsourcing, system integration, as we can see here, software development and licensing. At the recent years, mostly we have not only the licensing sector, but in the development sector. Okay, and telecommunications. And finally, there are disputes at not great, at a lesser extent, that have to do with design issues or distribution in the energy field, of course, at a lesser extent, because energy disputes mainly are, if I may say, of private international law, because there are most of the times countries involved. But we can see also there are disputes in this field as well. So this is a brief overview of what kind of disputes, of IP-related disputes or technology disputes we may find at the WIPE Arbitration and Mediation Center. Now, as we may guess from the disputes, we may guess who may concern these disputes, and the center who is going to enjoy the services. From the kind of disputes, we can say that it addresses services to everyone, from small or medium-sized companies to large companies, to startups, to R&D centers, even to universities. Okay, because we universities have become very competitive all over the world with patents, even trademarks. There is R&D going on. There is some great research going on, especially as from my knowledge, especially in the Central Europe or the Netherlands. There's a close ties between the university and the private sector. There are private companies that subsidize, in essence, university research. So universities are a category that may find relief at the WIPE Arbitration and Mediation Center. Of course, are museums in their respected field of interest, producers in the field of music and entertainment in general, collecting societies, has to do mostly with copyright and related rights, entrepreneurs, new entrepreneurs especially. Most of the times we have startups or even natural persons that apply for relief to the center. Inventors, of course, when we speak with patents, inventors or co-inventors, we have issues with co-inventorship. okay, or with transfer, or with joint ventures that have subsidized their patents and artists in general. So, and of course, other IP stakeholders. There's not a limit to the persons that can benefit from the WIPO's Arbitration Mediation Center. Now, it's a brief overview of the case load of the center. What is the work? What is going out there? We may say that's a great deal of work that the center has produced over the years. Over the last decade, more than 800 mediation and arbitration and expert determination disputes have been submitted, have been administered, to say it more correctly, by WIPO. I think it's a number that's not. It's quite a good number, serious number. This means that it has an appeal to all these actors that I've mentioned before, and it produces actually works in this field, in the ADR of this kind of disputes. If we want to see now how this is spread along the years, it is very interesting. That's why I've chosen to present it to you. It is very interesting that this number of 800 mediation, etc., administration disputes, it was not that high a decade before. As you can see from the charts, in 2011, only 41 cases have been administered by the WIPO, and the following years, except 2012 and 13, we have seen an increasing rate. And the interesting part is at the last 3 years, 2 to 3 years, there is an exponential growth. We each year we see now about 200 cases that are administered by WIPO. I think that is a very good sign that lawyers and all the stakeholders and the companies are headed to ADR, towards a more effective way of resolution, instead of having recourse to traditional litigation and national courts. So I think this is an increasing. There's a tendency here to increase, and if we're going to take into consideration the last, at least the last 1 year, I think the next year's chart is going to have a better increase. Because we have the pandemics, and there, as I said before, there was a shift to the internet, to the electronic world, in every respect, and a lot of disputes have proliferated in this field. Not just disputes that can be mediated or arbitrated via online. Via the internet, but disputes that have their origin on the internet. So I think the following years, these numbers are going to be higher and higher, and this, I think, this will be a good sign for the field of ADR. Now, another issue I would like to mention, because I have in the past examined it, was also the subject matter of my LLM thesis point, is the WIPO Arbitration and Mediation Center that deals with domain name dispute resolution. It is, if I may say, it is the last resort for someone, for a trademark owner and the domain name holder, to have recourse to WIPO's WIPO's service. As from from the beginning of this service, the number, as you can see, is quite high. 50,000 cases. 50,000 cases have been administered under the Uniform Domain Name Dispute Resolution Policy, the so-called UDRP, and the UDRP rules that the WIPO have adopted, and what these cases involved more than 90,000 internet domain names. In these cases, we can see that it's not just domain name cases. I mean, domain name fighting over domain name. Most of them are domain name owners as respondents, and the complainants usually are trademark owners. So we can see here that there is a dispute resolution method for a specific area of disputes, that is trademark versus, as I used to call it, trademark versus domain name disputes. Here we can see a lot of disputes that respond to the cyber squatting phenomenon, especially famous all over the world, and with the respondents usually at a great extent not only from China, when domain names, when trademarks are used as domain names to attract visitors or to gain from a trademark. And in this respect, I think UDRP is a very fast and low cost service dispute resolution policy has given a lot of help to trademark owners. Just think of a business that has a domain name that actually steals clients online day by day and minute by minute to wait for months. It's very optimist word to say, or years, to take down the domain name of the people that infringes the trademark. That will be catastrophic for the trademark owner. So I think WIPO's policy on that matter has given a great deal of help to trademark owners. And just imagine that it applies also to a great extent to domain names such as .com, which is the very common domain name, the most common we know by now, .net, .org, .top, .win, and of course the XYZ from the new domain names that have been introduced. In addition to that, we can see that there are disputes both on this field and on domain names that have to do with a country code top level domain names, which is also very important because it facilitates not just the basic domain names, but a lot of other 75 country code top level domain names. That's why the numbers of disputes are that high. Having said that, because I think it's actually one of the services that WIPO has succeeded in that area a lot. As we can see from the brief overview of these disputes, we can see that the filing of the name case filing to WIPO for the last decade, the cases that have been filed has been doubled since 2011, and we can see that 2020 more than 4,000 cases have been filed. I think that's a great success that can be seen in numbers. Having said that, I will just mention briefly another service and another opportunity that WIPO gives to IP right holders and other technology right holders. And this is the good offices service, because in many cases, as we can see later on, there are of course agreements on ADR agreements before dispute arises or after dispute arises. There are companies that have or individual players, if I may say, that know the ADR and have in place the clauses, ADR clauses. But this is not almost the case. There are cases that the parties need guidance in any field, even from the submission of their disputes, and even to what to the choice that of ADR or ODR method they are going to opt for. So WIPO provides procedural assistance to parties that are involved in such disputes, and also facilitates the submission, as I told before, but also the direct settlement between the parties, because we may have an early settlement of these disputes. So, as we can see from the rest of the services, I also give for everyone that needs more info on these services, which are very useful. You can find it at the WIPO site. There's the link, and another important service and important help, if I may say, of WIPO Center is the guidance and the information is provided. It's actually at a very good level. The parties are guided even in times that they don't have, at a certain point, they don't have legal advisors or lawyers with them at a certain point, because they want to keep the cost low. They have, in any case, guidance from the center, and also there are dispute resolution agreements, and it facilitates also the disputes that are non-contractual infringements, or even they accept cases that are pending before courts. So the issue, and in practical terms, if someone wants to refer his or her dispute to the WIPO Arbitration and Mediation Center, what we need to do? Of course, there is this is the referral we are talking about. The referral is mainly, and I say mainly because we have also arbitration clauses that are binding, but mainly the referral is consensual. It's based on the parties concerned and it's voluntary. Of course, this can happen after the dispute that has arisen, or before a dispute with a contractual clause. And there's also a parties agreement in this agreement included. Now, when we want to incorporate such a clause in our agreement, WIPO has given us also a great deal of help in this field, and gives us the clauses, the mediation clause, according to Article 3 of the WIPO mediation rules, to incorporate into our contract with the other party. There is, as you can see here, a model. Of course, it's a model contract mediation clause. We can modify it. We can make it shorter. We can make it more. We can elaborate more on the clause. This model clause refers to future disputes that may arise in the course of a business or of the parties after the signing of a contract. And we can see here that the clause states that we may refer to mediation any dispute, controversy, or claim arising under or out of or relating to this contract and any subsequent amendments of this contract, including without limitation its formation, validity, binding effect, interpretations, performance, breach, or termination, as well as non-contractual claims shall be submitted to mediation in accordance with the WIPO mediation rules. As we can see, it's a very inclusive, and that's the proper way to be, because we want to be very specific in that kind of clauses to avoid litigation. Especially we have seen that in the field of arbitration, to avoid litigation over the clause, because there are parties that will want to go to courts for their because maybe it's are better for them, are better in terms of result, and other parties that will want to stick to the mediation clause